migration, but the whole continent of Europe. Because I can tell all honourable and right honourable members, having spoken to almost every interior minister and immigration minister, not just in Europe, but in Egypt, in Tunisia, in Morocco, in Turkey, they all ask, when are you getting this policy up and running? Will it work? And they want it to work, because they know if we can create a sustainable deterrent, we will stop people coming, we will secure Europe's borders, we will save lives. And in an age of mass migration, this is one of the most important challenges that we have to face. I'll give way to the right honourable gentleman.
Sir Chris Bryant.
I completely agree with him about one thing. I don't think this bill will work. I don't think it will work if it has the amendments that he's tabled included in it either. And that is because I think he and I come to a completely different position as to the nature of the deterrence and whether it would work at all. Because it seems to me self-evident that there must be an enormous deterrent if you have to get in a tiny boat, risking your life as a pregnant woman with children beside you, having paid thousands of pounds to a vile, despicable people trafficker. What evidence does he have that this plan, gimmick, is any more deterrent than that?
Here, 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 here.
If the right honourable gentleman were right, then hundreds of thousands of people wouldn't be making that very journey every year. There are millions of people in the world who want to make this journey. There are thousands of people in France seeking to pay people smugglers to come to our country. The only way you will stop this is if you break the people smugglers' business model once and for all. So it is clear, beyond doubt, that if you come to this country, you will be detained and swiftly removed to Rwanda or to another safe country. And where the right honourable gentleman is wrong is he, like the Labour front bench, believe completely erroneously that you can arrest your way out of this problem. Yes. Well, the National Crime Agency don't support them in that contention, and I have not seen any evidence that that will work. Nobody who's looked into this problem believes that these fungible and complex gangs that stretch across Europe and beyond, who import boats for next to nothing from China and Bulgaria and Turkey, can just be arrested out of their existence. Everyone says the same thing: create a deterrent. That is what the Rwanda policy does. I won't give way again to the right honourable gentleman. Let me move forward and speak more directly to our amendments, because that's the purpose of today. The amendments that have been brought forward in my name and that of my honourable friend, the member for Stone, in 4 groups, 2 of which will be heard and discussed today, 2 tomorrow, seek to address the evident flaws of the bill. And they represent the last opportunity for us to get this policy right. Let me speak directly to the one that is in my name, and my right honourable friend for Stone can speak to the one which he leads. Mine speaks to individual claims, and this is a point that I have made time and again. All my experience at the Home Office teaches me that every single illegal migrant coming to this country will try every possible way to avoid being removed. We know that. That's what they do today. It's human nature that people would do this. You have to legislate for human nature, not against it. And every legal representative and lefty lawyer will try everything they can to support those claims. We see it every time. Experience teaches us this. Now, the bill does improve the situation. The bill makes it tighter, but only in respect of the general safety of Rwanda, not in respect of an individual's circumstance. So I'll give way to the Honourable Lady in a moment. So as night follows day, every migrant will say, Rwanda may be generally safe, and I believe it is, but it's not safe for me. And that is one of the central intellectual incoherences, as the government's own lawyers have said, at the heart of this bill. It envisages that Rwanda is generally safe, but for a range of unspecified reasons, foresees that Rwanda will not be safe for others. And of course, as we've seen in the past, one person will mount a successful challenge. That will create a precedent. Every legal representative and NGO like Care for Calais will then school everyone to make exactly the same challenge. And time and again, we will lose these cases in the courts. So the bill in that respect is legally flawed, but it's also operationally flawed because of that. And let me explain to those who are not as well versed as, understandably, those of us who've been ministers in this field are. We only have 2,000 detained spaces in our immigration removal centres in this country. On a single day in August, 1,200 people arrived illegally on our shores. So in a weekend, all the detained capacity in the whole United Kingdom would be consumed. So when you're considering whether this bill works or not, see it through that lens. We have to get people out of the country within days, not months. And the operational plan behind this bill foresees that people will take months to be removed from the country. So what will happen is that our detained capacity will be filled, people will then be bailed to hotels, they will then abscond and never be seen again. And within a single week in August, this scheme will have failed. Now, that matters for the country, of course it matters for the government, it matters for trust in politics and Westminster, because we will have told people it was going to work, knowing that it will not work, and it matters for all those other European countries who want this scheme to succeed, to protect our borders. Well, I'll give way to my honourable friend.
I'm grateful to my honourable friend, and he's making a good case for deterrent, but I fear a bad case for his amendments. As the Home Affairs Select Committee found out, when the Rwanda scheme was announced, there was a big surge of people in Calais trying to regularise their status in France because they didn't want to risk being sent to Rwanda. So deterrents do work. But does he not acknowledge, he's just said this is the last opportunity to get this right, that there is a very large chance that his amendments would make this bill unworkable, not least in the eyes of the Rwandan government, in which case we have no deterrents, so therefore what is the alternative then?
Question head on. I've known the honourable gentleman for a long time, and he wasn't born yesterday. That argument is not a plausible one, in my opinion. The argument that the Rwandan government would walk away from this scheme was raised almost at the 11th hour.
1 minute to midnight.
1 minute to midnight. It's predicated on the belief that the government of Rwanda would walk away from a scheme on the grounds that it might conceivably fall foul of the European Convention on Human Rights, which Rwanda is not itself a party to, and where the only reason we would fall foul of the European Convention of Human Rights would have been because of conduct in Rwanda itself. Yeah. I don't find that a plausible argument, I'm afraid. And if it were the correct response, why then pilot a bill through Parliament where on the very front page it says the government cannot attest to the fact that the bill is compliant with international law? Why would the Prime Minister say that he's willing to ignore foreign judges when his own legal advice says that that's in breach of international law? And why would we pursue a policy which the UNHCR has just said yesterday is, in their opinion, in breach of international law? I think this is not a plausible argument from the government. I think it was unwise for the government to solicit that press release from the government of Rwanda. I don't think that we should cast blame on the government of Rwanda, because I think that they are honourable people who want this scheme to work, and I have the highest opinion of our interlocutors in Rwanda, and it's for that reason that I want to do what we said we would do when my right honourable friend created the scheme, which is work with them in good faith to get the job done. I won't give way at the moment. Let me make some more progress on explaining the amendment, if I may. The way that flights will work when this scheme commences is not under the Illegal Migration Act that we passed last year at all. The first several months of flights will be through a group of individuals who my right honourable friend, the member for Whittam, and her officials at the time selected when the Rwanda policy was first devised. Those individuals have been in the United Kingdom for months or years, many of whom we've lost contact with, none of whom can be subject to the protections in the Illegal Migration Act. So even if you believe that the serious and irreversible harm test within it is a very strict one, and I'll come to that in a moment, that won't apply to the flights that will go off in the months ahead. It may not apply to any flights that go off before the next general election. So if you want those flights to be full of illegal migrants and there to be a deterrent effect, I think you need to support the amendments that I've set out, which create that strict approach. When we do, I'll give way in a moment. When we do come to those individuals who are subject to the Illegal Migration Act's strictures, the government's contention is that the serious and irreversible harm test is a very high one. I don't think that's right. I think the Supreme Court's judgment lowers the bar. The revealed preference of the judiciary is to be generous towards illegal migrants. It is to make this scheme difficult to operationalise. And as this is the last legal opportunity or legislative opportunity for us to tackle this issue, I suggest we get it right and we narrow the opportunities for the judiciary to intervene, or else we're going to find that these flights are symbolic flights with very few individuals on them at all. I will give way.
I'm grateful. I wanted to touch on something that you mentioned earlier on with regard to whether it will work at all. He's very often gone on the record as saying about the Albania scheme, which has been very, very successful. There's now 90% fewer Albanians coming across. In the year to September last year, 2,749 illegal migrants were returned to Albania. They didn't require these amendments, and the law that we currently have allowed them to be returned, and I don't remember hearing about any appeals from those people. So on that basis, and this bill is stricter than what we currently have, why won't it work if it already works on the Albania scheme?
Well, I've heard that argument advanced before, and of course I'm proud of what we've achieved with the Albania scheme, but I think that is judging two quite different propositions. The Albania scheme is taking somebody who is in the United Kingdom and asking them to return to their home country, a European country, a highly developed country. It's a very different proposition, I'd say, to my honourable friend, than asking somebody, in fact, not asking somebody, enforcing that they should be removed from the United Kingdom to a third country which they do not wish to go to. Also, as he may know, very few small boat arrivals have been removed to Rwanda, to Albania. Almost all of those individuals who have gone to Albania have been foreign national offenders in our prisons, time-served FNOs. They've been individuals who have voluntarily chosen to return to Albania, and those who've been in the United Kingdom for a long time. The success of this scheme rests on taking people off small boats, detaining them for very short periods of time, and then removing them swiftly to Rwanda. For the reasons I've just set out, I think that's extremely unlikely to succeed at any scale in the way the bill is currently structured. I'll give way to the Honourable Lady, and then I'll conclude my remarks, if I may.
Caroline Lucas.
I'm grateful to him for giving way and would just point out that people arrive in small boats because legal routes have been blocked. But when it comes to his amendment in particular, Clause 4 of this disgusting bill already provides a very, very limited route for individuals to challenge their removal to Rwanda based on their individual circumstances. Yet my understanding is that the Right Honourable Member is seeking to go even further to override individual legal protections. Even decisions which contain errors would not be open to challenge under his Amendment 22, as I understand it. How on earth is that fair or just or justifiable?
Well, on her first point, we've had this argument many times before, but she's completely wrong. This country is one of the world's most generous countries for supporting those in need around the world. And since 2015, we have issued more than 500,000 visas on humanitarian grounds, more than at any time in our history. On the point she makes about my amendment, it's not correct to say that we wouldn't enable people to challenge on their individual circumstances, but they wouldn't be able to be suspensive. So individuals would arrive in the UK, and within days, which is critical to the success of the scheme, they would be removed to Rwanda, where they could bring forward claims as they may wish, but they wouldn't block the flights. And that is critical, without which the scheme will simply not succeed. What we will also say, I won't give way to the right member, what we will also say in this amendment is that there are very narrow grounds in which individuals would not be put on flights, ones the Home Office are very used to dealing with through fitness to travel requirements. And that is a concept that's well known and understood, and I'm certain would work. So what does the amendment do that's different? It narrows down the reasons by which individuals could make claims and makes the scheme legally and operationally workable for the first time. Now, Dame Rosie, Sir Roger, Damascene conversion. We've tried to be constructive in bringing forward this and other amendments. The Prime Minister set a test to me and to anyone who shares my determination to tackle this issue. And that was as follows, that he would accept any amendment, whether it strengthened this bill, if there were respectable legal arguments in international law in their favour. Now, we can argue about whether that test is the right one. Personally, I feel very strongly that there are times when contested notions of international law should not surpass either parliamentary sovereignty or, above all, the interests of our constituents. And border security and national security are the prime responsibilities of any government. But that was the test. We've met the test. We instructed a very eminent lawyer, John Larkin, KC, former Attorney General of Northern Ireland, to provide us with an opinion. The opinion says that each and every one of the amendments in my name and that of the member for Stone are compliant with international law. Unless the goalposts have been shifted by the government, I see no reason why the Prime Minister and the Minister couldn't accept these amendments and enable us to strengthen this bill once and for all. Sir Roger, I'll conclude by saying this. At the outset, I said that there was one question hanging over this debate, what works. There is a further question. How much are we actually willing to do to stop the boats? How are we willing to take on the vested interests, balance the trade-offs, take the robust steps that will actually work? The only countries in the world that have fixed this problem, latterly Australia and Greece, have been willing to take the most robust action. Are we? Well, I am. I want to stop the boats and secure our borders. This is a difficult issue, but we're not a parish council struggling with some kind of intractable legal issue. We're a sovereign parliament. The power is in our hands. We have agency. The law is our servant, not our master. I would urge all right honourable and honourable members to support the amendments in my name and those of my honourable friend, the member for Stone, and create a scheme that actually works. That's what our constituents expect of us. That is the promise that the Prime Minister has made to them and the whole country.
Hear, hear.
Opposition front bench, Stephen Kinnock.
Thank you very much indeed, Mr. Chairman. I rise to speak in favour of Amendments 35 and 37 and new Clause 6, tabled in the name of the Shadow Home Secretary and myself. But may I just start by reminding the House and anyone watching at home that the Labour Party is opposed to this bill in its entirety, for the simple reason that we are opposed to the Rwanda scheme in its entirety. We have been absolutely clear that we need to stop the Conservative small boats chaos, and we need to fix our broken asylum system. But those aims can only be achieved by way of measures that are based on common sense, hard graft and international cooperation, as opposed to headline chasing and government by gimmick from the benches opposite. Now, the benches opposite like to accuse us of opposing everything that the government is doing to stop the Tory small boats chaos, but that is simply not the case. We on these benches fully support measures such as the deal with Albania, because that is the sort of sensible, pragmatic action that can make a tangible difference. And we've repeatedly made our support for this course of action crystal clear, if only the benches opposite would care to listen. But the Labour Party will never support any proposal that is unaffordable, unworkable or unlawful. And Mr Chairman, I will give way.
I thank my honourable friend for giving way, and would he agree with me that the government is being extremely neglectful with the public purse by throwing money at the Rwanda scheme that simply will not work?
Well, my honourable friend is absolutely right. It's quite remarkable that a party that used to pride itself on being the party of fiscal rectitude is throwing £400 million of taxpayers' money at the government of Rwanda for precisely nothing. The only thing they've got so far is they've sent 3 Home Secretaries to Rwanda, but not a single asylum seeker. And Mr Chair, the Rwanda plan is all of the above. It is unaffordable, it is unworkable, and it is unlawful. It's unaffordable to the British taxpayer because a truly staggering £400 million of our taxpayers' money is on the way to the Rwandan government without a single asylum seeker landing in Rwanda. It's unworkable because we know that the Rwandan authorities are only capable of less than 1% of the 30,000 who crossed the channel in small boats in 2023, according to the Court of Appeal. In order for a deterrent to be effective, it has to be credible. And surely even the most ardent supporter of this policy would acknowledge that such a tiny chance of being sent to Rwanda is ever going to deter someone who has risked life and limb to cross continents to escape from persecution and violence.
The Foreign Office recently admitted that hundreds of Afghans eligible for resettlement have not been brought into the UK. They exemplify the need for safe and legal routes. And is it not a case that those are exactly the people who are risking life and limb because they cannot get the legal and safe routes that the government should provide?
The Honourable Lady is right, and a case in point, of course, is the Afghan schemes. The Arab scheme has more or less collapsed. The ACRS is not working at all. And which nationality is always in the top 2 or 3 to be crossing on the small boats? The Afghans. It's pretty straightforward. So we oppose the Rwanda policy because it's not a deterrent, it's a distraction. Far better, as the Shadow Home Secretary and myself and others have set out many times in this chamber, to redirect the vast quantities of taxpayers' money that are being wasted on the Rwanda scheme into a new cross-border police unit and into a new security partnership with Europol, which can smash the criminal smuggler gangs upstream. I will give way.
I'm very grateful. I think he's making a really important point about how we need to be cooperating much more intensively with the law enforcement agencies across Europe. The brutal fact is this: these gangs are putting people into boats that were made for rivers, not sea, in treacherous conditions. I mean, who in their right mind would go in one of those dinghies in the English Channel right now? But people are being forced to do that by these gangs. We need to smash the gangs, and we can only do that by working with our colleagues across Europe to make sure that we bring this to an end.
My honourable friend is absolutely right, and if we accept that international cooperation with our European partners and allies has to be at the heart of the dealing with the gangs, as he so eloquently sets out, the possibility of that cooperation is fundamentally undermined when we have a government that is flagrantly prepared to break international law, which should underpin the trust that is a prerequisite for all of this cooperation to happen. So this cooperation based on joint working and intelligence sharing with our partners and allies is only possible if Britain is deemed to be a trustworthy partner. And that brings me to the third reason for us opposing the legislation that's before us today and for opposing the amendments that have been tabled by so many on the benches opposite. Because, Mr. Chair, we find ourselves in an utterly extraordinary position. We find ourselves debating a government policy which has been found to be unlawful by the highest court in our land. Amendment 35, which I'll come to shortly, reflects that very fact. And we find ourselves confronted by a government that is seeking to legislate for an alternative reality. Because whilst ministers appear to believe that they can pass a bill which determines that the sky is green and the grass is blue, that does not make it so. I will give way.
Has it escaped the honourable gentleman's notice that there was one claim that was dismissed by the Supreme Court judgment on Rwanda, and that was in Iraqi, the case of ASM. And the reason for it is very simple. And the court made this crystal clear in paragraph 144 of its judgment that the issue in question was undermined, as far as that claimant was concerned, by clear and unambiguous words in an act of Parliament. In other words, the sovereignty of Parliament prevailed.
I thank the honourable gentleman for his comments, but the point with the sovereignty of Parliament, of course, Parliament is sovereign. And of course, we in this place are sent here to make laws. But we must make those laws with restraint. We must make those laws whilst respecting the judicial function. The separation of powers is fundamental to our identity as a liberal democracy. So whilst he does very often talk about the sovereignty of Parliament, it is absolutely vital that his comments must always be founded on the principle of the checks and balances that the separation of powers gives us. I will give way.
Well, Tim, just to tease out a little bit more what Labour policy is on that specific issue that he referred to, is he ruling out any consideration of this House determining to overturn the wrongful convictions of hundreds of sub-postmasters simply because that would be setting a new precedent in the relationship between this House and the courts?
Well, that's an interesting one. I didn't have it on my bingo card today to be talking about the sub-postmasters scandal. Look, Parliament is free to legislate in any way that it wishes, but it has to do so taking full recognition of the view of the courts. And I note that a number of eminent legal experts have raised some concerns about the government's proposed approach on the sub-postmasters. We have to see precisely how the detail of that looks, and it is our duty in this Parliament to scrutinise that very carefully and to ensure that we're not setting dangerous precedents. What I would argue is there is no doubt whatsoever that the bill before us today is a deeply dangerous, profoundly dangerous precedent because it seeks to directly overturn the findings of the highest court in our land. And I would argue that that is a toxic approach, Mr. Chair. I'll give way to this.
Very grateful to the Shadow Minister for giving way. Has he not seen all the comments and budget lines that this government has put out, stating that it is cooperating extensively and fully with continental countries over trying to crack down on this awful trade which is leading to deaths in these small boats, and that the proof of that is that money is sent to France in order to help them with their tasks, and there is no evidence that they're not cooperating?
I thank the honourable gentleman for his comments. The cooperation with France is to be welcomed. The problem with it is it's too far downstream. What we need to see is far better cooperation upstream, which is about sharing data, fixing the issue with the databases. My honourable friend, my right honourable friend, the Shadow Home Secretary and the Leader of the Opposition visited Europol recently to come forward with very practical and detailed plans around getting the data sharing right. And that may actually then address the issue that the number of prosecutions of criminal smuggler gangs is going down on this government's watch. The number of returns and removals has gone down by 50% since 2010. So I think it's, again, we go back to this point about let's put more energy and resources into the pragmatic, sensible things that can actually make a difference, as opposed to being distracted by this madcap Rwanda scheme. So, Mr. Chair, it's a mark. I will, if I could just make a little bit of progress. Mr. Chair, it is a mark of a liberal democracy that courts are independent of Parliament and the executive. And we on these benches believe passionately that this separation of powers is a fundamental and immutable element of what makes us proud to be British. So we on these benches are not only opposed to the specifics of this bill, Mr. Chair, we are also deeply troubled by what it represents in a broader sense. And I will give way.
Over the Christmas period, the Labour front bench anonymously briefed The Times to say that they would want to pursue an offshore processing model. Is that correct, that it is his position and that of the Shadow Home Secretary? And if so, why would they want to do something which is known to be more expensive and less effective because you have to bring everyone back to the United Kingdom one way or another, and so you create no deterrent whatsoever, but one wouldn't want to move forward with a scheme like Rwanda?
Well, I thank the former immigration minister for his comments, and I must say I did enjoy opposing him and working with him on some occasions, and I thank him for his comments. What I would say is that if you look at the Ukraine scheme, that is an example of offshore processing. Those applications were processed in Poland before they came to our country. Look at the Hong Kong scheme. There are plenty of ways of doing upstream processing, offshore processing, and to coin a phrase, what matters is what works. And what is absolutely clear is this Rwanda, and it's difficult to imagine any scheme that could be more expensive than this one. But I'm going to make some progress. What I would cite is the view of the Bingham Centre for the Rule of Law and countless other legal experts who have stated that this bill is contrary to the rule of law because it amounts to a legislative usurpation of the judicial function. It is an assault on our country's constitutional conventions, which require the legislature to respect the essence of the judicial function. Moreover, there is a staggering hypocrisy at the heart of this bill when you consider it in the context of the treaty that has been signed with Rwanda. Because the purpose of that treaty is to bind the Rwandan government into respecting the rule of law, and in particular the principle of non-refoulement. But how on earth can ministers hold the Rwandan authorities to account on these matters if they themselves are so blatantly and egregiously failing to practice what they preach?
The Honourable Gentleman, it is a little disingenuous to liken the Ukrainian scheme. The only criteria for the Ukrainian scheme is you had to be Ukrainian and come from Ukraine. He just mentioned enforcement, and he said that it had gone down. So up to the end of November 2023, Home Office Immigration Enforcement arrested over 246 people for people smuggling into the UK, and there were 124 convictions. And that is in addition to those arrests and convictions which have happened in the continent. So on what figures that he's just claimed were those figures a decline?
There's been a 30% drop since 2010 in the convictions of criminal smuggler gangs, and there has been a 50% drop since 2010 in removals. I'd be very happy to write to the honourable gentleman with the clear details of that fact. We've got the receipts. So, Mr. Chair, it is against this fundamentally flawed and farcical backdrop that we seek to modify the legislation that is before us today. Our amendments are an attempt at damage limitation, an effort to moderate the most egregious aspects of this nonsensical and counterproductive bill. Our Amendment 35 acknowledges that, in November of last year, the Supreme Court upheld the Court of Appeal judgment. It ruled unanimously that the Rwanda policy was unlawful because there were substantial grounds to believe people transferred there could be sent to countries where they'd face persecution or inhumane treatment if Rwanda rejected their asylum claims, a practice known as refoulement. The reason for these concerns relate to an issue that I first raised at this dispatch box back in April 2022, when the Rwanda plan was first announced. And that is the fact that when Israel signed its deal with Rwanda in 2013, many of the asylum seekers who were sent from Israel to Rwanda were routinely moved clandestinely to Uganda. And in 3 cases, refoulement to Eritrea via Kenya was only prevented by the UNHCR intervening. Little wonder that the Israeli Supreme Court ruled the scheme unlawful in 2018, and it was closed down. In December, the government signed a treaty with the Rwandan government which says that refoulement is prohibited and says anyone removed to Rwanda from the UK must be allowed to stay in Rwanda. Indeed, the only country to which people can be transferred from Rwanda is the UK, which under the deal must also accept some of Rwanda's most vulnerable refugees and offenders sent back from the country. This fact in itself tells a story, Mr. Chair. The fact that the UK government and the Rwandan government have agreed that Britain might need to take some Rwandan refugees is a stark admission of the fact that Rwanda is not a safe country for many people. Indeed, since the first £120 million payment by the British government to Rwanda, 6 Rwandans have been granted safety and refuge in the UK. And then there is the tragic fact that ministers are simply too afraid to address that in 2018, 12 Congolese refugees were shot dead by Rwandan police for protesting against food shortages. Mr. Chair, our Amendment 35 therefore permits British courts and tribunals to recognise and deal with the specific risks of refoulement associated with Rwanda by removing the relevant text in Clause 2 of this bill. Likewise, our Amendment 37 makes it clear that decision makers must be able to take the risk of refoulement into consideration when processing asylum claims. The bill designates Rwanda as a safe country and therefore makes clear that every decision maker must conclusively treat the Republic of Rwanda as such. It states that the bill does not permit a decision maker to consider any matter, claim or complaint to the extent that it relates to the issue of whether the Republic of Rwanda will or may remove or send the person in question to another state in contravention of any of its international obligations, including in particular its obligations under the Refugee Convention. Yet, as the government has previously acknowledged, the facts on the ground can change, and therefore it must be acknowledged that decision makers should be able to make their own judgments based on the latest court rulings. So we see no reason not to let decision makers do their jobs and make decisions based on all the knowledge available to them as the situation evolves, as opposed to the frankly absurd idea that Rwanda can be defined as safe in perpetuity. I turn now to our new Clause 6. The new treaty states that Rwanda is committed to addressing concerns that are laid out in the Supreme Court judgment, including refoulement. New Clause 6 would simply help to ensure that Rwanda can be held accountable on its treaty commitments by placing the monitoring committee for the Rwanda Treaty on a statutory basis and by placing conditions on when the classification of Rwanda as safe can be suspended in accordance with the material conditions and or non-compliance with obligations under the Rwanda Treaty. As things stand, the government could vary the operating principles of the Monitoring Committee without it being possible for such changes to be challenged in our domestic courts. Our new Clause 6 therefore addresses this unacceptable position by placing the Monitoring Committee on a statutory footing, thus making it justiciable and thus, by definition, more transparent and more accountable. We see no reason why members opposite and across this House should oppose the principles of transparency and accountability upon which our new Clause 6 is based, and we hope they will join us in the I lobby later. Turning briefly to the amendments put forward by members opposite, I would point out that even one of their own colleagues, the chair of, I believe it's called the One Nation Group, has described many of these amendments as authoritarian and a betrayal of conservative values. And he's right, Mr. Chair. The bill in its current form is already an assault on our reputation as a country that upholds the separation of powers and the rule of law. And the majority of the amendments tabled by the benches opposite would take us even further away from those basic democratic principles. So let me be clear. We on these benches will be proudly voting against the amendments that are being promoted by the benches opposite, because the government's Rwanda policy is unaffordable, unworkable and unlawful, because this bill is an affront to the values that we hold dear, and because we will always stand up for the separation of powers, for the rule of law and for ensuring that we can stand tall in the world.
He's very kind to give way a second time. I've listened to him carefully, and I don't have an answer to one of the central questions of the debate. Is the government's view that Rwanda is a safe country? What is the view of the Labour Party? Is Rwanda a safe country? I think we would all be interested to know, and I know the government of Rwanda would be interested to know the Labour Party's position.
Well, I thank the honourable member for that intervention. I don't think I could have made it any more clear that we believe in the rule of law and in the judicial function. And when the Supreme Court of our land rules that it is not safe to send asylum seekers to Rwanda, we on these benches agree absolutely with that position. Mr. Chair, we've seen some pretty bizarre stuff emanating from the benches opposite over the decades. But when the history books of the last 14 years are written, Their psychodramas over this Rwanda policy will surely take centre stage. Just think of the astonishing amount of government time that's been ploughed into this unaffordable and unworkable nonsense, when ministers and officials could have been focused on the design and delivery of the sort of sensible, practical measures that I mentioned earlier. And just think of the vast amounts of political capital that the Prime Minister has squandered on a policy that he doesn't actually believe in, and that his Home Secretary has privately poo-pooed, if you'll pardon the pun, Mr. Chair, and that has left his leadership in tatters. The legislation before us is a sham. But in the interest of damage limitation, I urge members to get behind Labour's amendments today. And of course, most crucially, I urge members to vote down this bill at third reading and get behind Labour's plan to deliver the security partnership, the cross-border police unit that will smash these criminal gangs and defeat the people smugglers and will stop the Tory boats chaos once and for all.
Sir William Cash.
Mr. Chairman, we want the bill to succeed. We want it to work, and we want to do what our voters want. But at present, it does not. Clause 2, as it stands, does not work, and that is why I shall put my Amendment 10 to a vote, supported as it is by well over 60 members of Parliament. Clause 2 of the bill needs to be amended with clear and unambiguous words and with a full notwithstanding formula, not the one that is currently on offer. This formula has been used throughout our legislative history for hundreds of years, but most recently it's been enacted in our most important domestic and constitutional legislation without opposition, namely in Section 38 of the Withdrawal Agreement 2020. The sovereignty of the Crown in Parliament is democracy and is described in the leading case by the great Lord Bingham, our greatest modern jurist, as the bedrock of our Constitution. Democracy delivers the wishes of the voters who elect us through the legislation that we pass as Acts of Parliament, and it is this democracy for which people fought and died. Nothing could be more important to their daily lives, including illegal immigration, and that is why this issue is so important. But it is also important to stress that genuine refugees are fairly protected, as this country always has, as in the case of Afghanistan, Hong Kong, and so forth. Yesterday's YouGov poll makes it clear how strongly people feel about all this. It is a legal, constitutional, and also, therefore, essentially a political problem. The reason why sovereignty is so fundamental is that the courts recognise that they have a duty to interpret, adjudicate, and obey the laws and acts made under that parliamentary sovereignty, where legislative words are clear, express, explicit, and unambiguous. Therefore, the use of a comprehensive notwithstanding formula, as in my amendment, would ensure that we make this bill work in line with the intended purposes of the bill and not be frustrated by claims of international law or other contrary law. This bill in its current form will not prevent, as everyone knows, further ingenious individual claims followed by further Supreme Court decisions. The recent Supreme Court judgment itself on the 15th of November 2023, as I pointed out in intervention, makes my very point. It shows that the words in the Immigration and Asylum Acts at that point in time were not clear and unambiguous, but, and this is vital, it seems to have escaped many people's notice that one of the claimants, ASM and Iraqi, had his claim dismissed in that very judgment because, in the words of Lord Reid, the President of the Supreme Court himself, I quote, "In any event, the principle of legality does not permit a court to disregard an unambiguous expression of Parliament's intention, such as that with which we are concerned," I say to the honourable gentleman on the front bench, "with which we are concerned in the present case." This was emphatically because the retained EU Law Act and related immigration legislation was so clear and unambiguous in that case as to require the court to dismiss the claim of the Iraqi precisely as a matter of parliamentary sovereignty. This Rwanda, of course.
Did my honourable friend, who's doing a wonderful job as always in these areas, see the recent briefings that seem to come from the government, that they're expecting a lot of cases under their law, and they're going to provide a lot more judges to do it? Aren't they telling us that it isn't going to work?
That's right.
I'm afraid to say that that does appear to be the inevitable inference to be drawn from the statements that have been made. And the worry is that unless the law is completely clear and unambiguous, there's going to be more trouble. And if this bill was to be passed with clear and unambiguous words, they wouldn't be needing the judges that they seem to be wanting to employ, nor for that matter all the fees that the lawyers will accumulate as a result of taking part in some very spurious cases. So, as I've said, the Rwanda judgment is in line with all previous judgments by preeminent jurists in recent generations, and I mentioned but a few: Lords Denning, Lord Reid, Lord Hoffman, Lord Bingham and others. Months ago, I sent the Prime Minister a 7-page memorandum, each line of which set out breaches of international law in almost every jurisdiction in the world, including even the EU itself, the United States, France and Germany, where clearly apparent breaches of international law have occurred and without international sanctions. As to the Vienna Convention, what really matters is whether the internal domestic law is of fundamental importance in the national interest. And this illegal immigration law manifestly is. We have in the UK a dualist system of law where the sovereignty of Parliament is fundamental to our rule of law and cannot be trumped by international law, by the opinions or conventions of the government legal service, or, speaking as a former Shadow Attorney General, if this be the case, even by an Attorney General. We have a dualistic approach to these matters, in which domestic law and international law are seen as independent of one another. And in the recent Miller 1 judgment, at paragraph 57, it states, "Our dualist system is a necessary corollary of parliamentary sovereignty. It exists to protect Parliament, not ministers." Furthermore, as Lord Hoffman made so clear in R versus Lyons in 2002, the courts will have regard to the words of the statute, not the treaty. This is because we have no written constitution defining the internal status of international law within the United Kingdom. As Lord Bingham has said, international law is, quote, complementary to the national laws of individual states and in no way antagonistic to them. Close quote. International law is not supranational, unlike European law. British courts cannot deem a statute unconstitutional. Under our constitution, it's the King in Parliament who legislates and not His Majesty's government. I thought they'd learned that in the Civil War in the 1640s. And the court does not require to have regard to functions of government when interpreting the law. A statute, even one arising from an international treaty, will always prevail over a rule of international law. Lord Hoffman, in the case of R versus Lyons, 2002, stated, and I will quote what he says, I can't improve on it, "It is firmly established that international treaties do not form part of English law and that English courts have no jurisdiction to interpret or apply them. It is not the treaty but the statute that forms part of English law, and English courts will not, unless the statute expressly so provides, be bound to give effect to interpretations of the treaty by an international court, even though the United Kingdom is bound by international law to do so. The sovereign legislator in the United Kingdom is Parliament. If Parliament has plainly laid down the law, it is the duty of the courts to apply it, whether that would involve the Crown in breach of an international treaty or not. Nothing could be clearer." In Bradley and Ewing's authoritative book, Constitutional and Administrative Law, it is clearly stated that the legislative supremacy of Parliament is not limited by international law. The courts may not hold an act void on the ground that it contravenes general principles of international law. Indeed, the Labour government in 1998 specifically reaffirmed the sovereignty of Parliament in relation to its Human Rights Act, saying it would not seek, to quote, would not seek to transfer power from future parliaments to the courts because it would confer on the judiciary a general power over the decisions of Parliament and would draw the judiciary into serious conflict with Parliament. Their own white paper stated, I quote, "There is no evidence to suggest the judiciary desire this power, nor that the public wishes them to have it." I do wish the honourable gentleman on the front bench was listening to this, because it's about the Labour Party. This still applies today. Indeed, under paragraph 53 of the House of Lords Constitution Committee report on the 18th of January 2023, the committee accepts that UK domestic law can, and I quote, diverge from obligations agreed by the government under an international treaty and ratified following the CRAG procedures. Parliamentary sovereignty means that Parliament could legislate to ensure that domestic law differed from the requirements of a treaty. And in paragraph 54 they state, Parliament, having enacted legislation that is not compliant with UK's international obligations, the courts are bound to apply that law. And further in paragraph 58 they go on to say, parliamentary sovereignty, and I quote, means that Parliament can legislate contrary to the UK's obligations under international law. So there we have it. And I should add that many members of that committee, like Lord Faulkner of Thoroton, are certainly not Conservatives nor Brexiteers. So there we are, we're all agreed. So in our unique unwritten constitution, our sovereignty patently prevails over international law, which is, I say by way of contrast, for example, with that of Germany. And what happens there? Article 25 of their written constitution, which I've taken from an established work on public international law, states as follows. These are the words of the very constitution in Germany. The general rules of public international law are an integral part of federal law. They shall take precedence over the laws and shall directly create rights and duties for the inhabitants of the federal territory. Similar provisions, for example, apply under the Dutch Constitution, Articles 65 and 66. So what does this tell us? That there is a dualist system and that some countries take a view which is different from ours. We just happen to be on the right side of the fence. Similar provisions may be applied by specialist international lawyers, and they may seek to make out that international law in this country prevails over clearly explicit words in acts of Parliament and parliamentary sovereignty. But there is no House of Lords or Supreme Court case which supports this proposition. I give way.
Very much enjoying his speech as always. And he gave the example of Germany, but even as for obvious historical reasons, they've imported principles of international law into their own domestic constitutional law. For example, the German Supreme Court, the Federal Constitutional Court, still reserves its right to be the final arbiter whether, for example, European Union law is incompatible with the German basic law.
Well, I'm extremely glad that my honourable friend has made that point, because actually I had the disobliging necessity to read some of the Supreme Court judgments from Germany, and believe me, sometimes they run to nearly 1,000 pages for the very simple reason that they're struggling to find something which will support the German people as compared to some of the rules of law which are applied more generally from on an international footing, which causes them so much trouble. So, as I've said, the European Union, and the point my honourable friend just made makes my point for me, is itself in a complete mess on this issue of illegal migration, and we are well out of it. It still has the Charter of Fundamental Rights, which we excluded in our withdrawal agreements, and legal changes to its immigration law, all of which will require hotly contested constitutional changes and referenda in its member states. They're going to be bedevilled by referenda, by constitutional change. I fear they will not succeed. Very many are up in arms about compulsory quotas and fines for non-compliance, being imposed upon them under the new Asylum Pact, Immigration and Asylum Pact, and which was passed by a majority vote. And it's noteworthy that recently the French government defied rulings of the Supreme Court regarding the deportation of an Uzbek national, but cannot apparently trace him as ordered by their own Supreme Court. By reference to the barracking I'm receiving at the moment, I'd simply point out the relevance of this is that we're talking about our constitution, which can solve the problem, and theirs, which cannot.
I wonder if my right to
I certainly will.
Of course, he's making a compelling argument about the difference between this country and those abroad who failed to take back control when we did. And he will know that constitutionalists from Dicey to Denham, from Lord Wolfe to Lord Summerton, agree with him that this place is supreme and the supremacy of Parliament is at stake as we debate his amendment and this bill.
Well, I have to say with all humility, if I may, that it's not so much that I agree with them or that they agree with me, but that this is the law of our land, this is the rule of law as it applies to the United Kingdom. And it is a tribute to the British people that they took that decision in 2016. As I said to the Prime Minister in December's Liaison Committee meeting, he himself can be a world leader on this illegal migration issue, not only in the EU, but also in the United States, in Canada, in Australia, every country in the world. The International Refugee Convention, among other conventions, is seen as requiring reform. And in Europe, it is clear that they need to change the European Convention on Human Rights, as well as EU immigration law, and the European Union voters are voting with their feet. This bill, nor the amendments are in breach of the present Refugee Convention, as this convention does not prohibit states outsourcing asylum claims and settlements to a third country. Similarly, the European Convention does not prescribe how its rights and freedoms are to be secured. Moreover, there has been, and I quote the words, a fundamental change of circumstances in the increase of illegal migration, criminality and the deaths that these have incurred since the Convention was created. So it is clear that the currently described obligations, as they're put, must take account of this change. We have to keep up with the times. And mass immigration is one of the main issues before all nations. So what is more important? Passing a bill that works and is consistent with the democratic will of the people and our national interest, our constitutional arrangements and parliamentary sovereignty, or supporting the uncertainties and vagaries of international law. Far from diminishing our international reputation, we now have the opportunity to enhance it by demonstrating that we can deal with illegal migration by making this bill work through our own parliamentary sovereignty. And we can bring an end to the deaths in the Channel. It has also been suggested, I have to say, that it is improper and contrary to the ministerial code to bring in a bill which is inconsistent with international law. This seems to permeate the legal establishment of this country. This is nonsense on stilts, because any member of parliament, any unimportant member of parliament, as well as ministers, any backbencher can propose legislation, and private members' bills are enacted frequently, as I have to say, even with my International Development Act of 2014. The acceptance by the noble Lord, the Lord Cameron of Chipping Norton, when he was Prime Minister, despite resistance from the legal establishment at the time that we could refuse prisoner voting, as insisted upon by the Strasbourg Court, is well known and remembered. The former Lord Chancellor and Secretary of State for Justice, the Right Honourable the Lord Clerk of Nottingham, King's Counsel, said that when we refused to accept the, quote, international obligation under the European Court of Human Rights to allow prisoners to vote in elections, he said that, quote, sorry, I mustn't laugh, prisoner voting was a particular political issue. So what about illegal migration? The 2023 House of Lords report makes much of the Ministerial Code and the Civil Service Code, stating, and I quote, that while Parliament is ultimately responsible for the form of any legislation passed, the preparation and introduction of government legislation is an executive action for which ministers collectively are accountable. They then go to reaffirm their disquiet about the constitutional desirability of Parliament legislating in violation of UK international obligations. But they ignore the principles of parliamentary sovereignty, where words in acts of Parliament are used and are clear and unambiguous. And moreover, the Ministerial Code is a convention, not legislation. The words in that code some 10 years ago did, once upon a time, state that the Ministerial Code included the words, quote, an overarching duty on ministers to comply with the law, including international law and treaty obligations. But these were expressly removed from the code in 2015 by the then Prime Minister. The current 2022 Ministerial Code under the present Prime Minister simply refers to the law. This is no accident. The government has declined the Lord's invitation to bring back the words, quote, international law and treaty obligations, and I would say quod erat demonstrandum. The House of Lords Committee also suggested, in reference upon a Court of Appeal case of the Gulf Centre for Human Rights against the Prime Minister in 2018, and a statement 5 years ago by the noble Lord and distinguished Lord, the Lord Folkes KC, that the Ministerial Code still requires compliance with international law obligations. However, I have to say, the Court of Appeal, sadly for them, did not deal with the issue of parliamentary sovereignty, which would be combined with the use of words clear and unambiguous, and in any case did not concern an Act of Parliament. Failure to pass a bill to effectively deal with illegal migration has led to vast public expenditure, billions on services including healthcare, education, social care, housing, infrastructure, planning, just to name a few, not to mention millions and millions on hotel bills. This is why people are so cross, as well as the fact of illegal migration. There is no reason whatever why this bill should not expressly and clearly exclude international law for and within the reasons I have given. It is an affront to Parliament and to the courts to suggest otherwise. I therefore ask that my amendment be voted upon and passed by the House, and I strongly urge the government to note the sheer anger and frustration demonstrated in opinion polls and public concern that we get this bill right and make it work. If not, this anger will continue up to and including the general election. Would it not be wise for the government to reflect on the position, and that it would be better and wiser to come forward with their own amendments and use our majority in line with our manifesto, granted to us by the general election in 2019 and in the national interest, and for the sake of all Conservative members of Parliament whose seats will be so at risk if we do not do so.
Yeah. Dave Diana Johnson.
Thank you, Sir Chair. I'd just like to start by raising my concerns with the government about using a committee of the whole House for this part of the scrutiny of the bill. We had this with the Illegal Migration Act. And what happened was, in that case, there were hundreds of amendments, and the Minister just got to speak at the end for a very short period of time. Now, I think when we're debating and scrutinising bills like this, we need to do so line by line, and we need to debate, and we need to hear the argument from the Minister and the argument from the proposers of amendments. And I just think that this process that we're going through does not allow Parliament to conduct that effective scrutiny that we all want to see when passing laws in this place. So, turning to the bill before us today, when the Home Affairs Select Committee published our report on Channel Crossings 18 months ago, we were very clear about the potential problems posed by the Rwanda scheme. And as I've highlighted on several occasions in this chamber, we said that the small boat crossings is an issue on which no magical single solution is possible, and on which detailed, evidence-driven, properly costed and fully tested policy initiatives are by far most likely to achieve sustainable incremental change. We warned the government that it risked undermining its own ambitions and the UK's international standing if it could not demonstrate that the scheme was compatible with international law and conventions, and that aspects of it carried significant reputational risk to the United Kingdom. Now, contained in the amendments today that we're debating are provisions that not only are incompatible with the UK's obligations under international law, but to basic principles of liberty and freedom under common law. The implications of these amendments are therefore profound and affect, I think, every single one of us. And also, despite what the former immigration minister said, I do take in all sincerity what the Rwandan government's view is on the importance of upholding international legal obligations. We can conclude that some of the amendments tabled today would prove fatal to the implementation of the bill, and indeed yesterday the UN Refugee Agency declared that the Rwanda Treaty and this unamended bill are, I quote, not compatible with international refugee law. So I want to speak to amendments 2, 3, 10, 56 and 57 and then focus my comments on amendments 19 to 22. Turning to amendments 2 and 3, excuse me, they would prevent any claim based on risk derived from individual circumstances being considered until that person in question had arrived in Rwanda. This would effectively exclude the very narrow possibility for suspensive claims that the bill currently allows, and could result in the person being exposed to the risk on which their claim is based, including claims based on fear of persecution and torture before it's even considered. The European Convention on Human Rights requires independent and rigorous scrutiny of any claim that there exists substantial grounds for fearing a risk of treatment contrary to Article 3. It also requires that the person concerned should have access to a remedy with automatic suspensive effect. So these amendments would therefore be inconsistent with that requirement of the ECHR. Moving on to Amendment 10, that would extend the notwithstanding provision to apply to all of the bill and to the Illegal Migration Act. It would effectively prevent a claimant relying on any pre-existing legal protection to prevent or delay their removal to Rwanda. This amendment would expressly allow for a removal to Rwanda despite that removal otherwise breaching domestic law, and despite that removal being in breach of international law, including fundamental human rights, from which, of course, we know no exception or derogations are permitted, such as the prohibition on torture. Needless to say, this amendment is not compatible with the UK's obligations under international law and risks undermining our international standing. Amendments 56 and 57 would provide that courts and tribunals would not be permitted to consider a claim on the grounds that Rwanda is not a safe country, where the claimant has engaged in activity or made serious allegations that have brought into question the safety of Rwanda, or colluded or conspired with others who have done the same. Very worryingly, the amendment appears to exclude people who have made serious allegations about the safety of Rwanda from asylum and human rights protection. This would be inconsistent with rights to asylum and humanitarian protection under international law, and could also be inconsistent with freedom of expression as guaranteed under Article 10 of the ECHR. Just want to turn to amendments 19 to 22, amendments that I think have profound implications for all of us. Those amendments would prevent any individual set to be removed to Rwanda arguing that they could not be sent there on the basis of their own circumstances. In the inevitable absence of absolute certainty that no risk to any individual could arise in Rwanda, this would mean that legitimate claims based on a real risk of persecution and human rights violations would not be heard, and that those people whose claims are unheard would be removed to face that persecution and human rights violations in Rwanda on which their claims are based. This is clearly inconsistent with the Refugee Convention, the ECHR, and the other international legal obligations cited by the Supreme Court in its recent judgment. Amendment 22 would also prevent the courts from reviewing not only asylum claims of individuals being sent to Rwanda, but also claims for unlawful detention, for assault in the course of removal, or for discriminatory treatment in the course of the removal process. So I just want to be clear, denying these claims would not only be inconsistent with human rights law, but also with fundamental principles of liberty and freedom under our common law, which has been protected for centuries, including by the writ of habeas corpus. And all members who do not want to see habeas corpus sacrificed today can surely not sacrifice these particular amendments. Finally, I'd just like to add my voice to amendments that I believe to be sensible and logical revisions. I'm just going to carry on because I want to deal with Amendment 1, which requires the Secretary of State to monitor whether Rwanda remains a safe country, and new Clause 6, which places conditions on when the classification of Rwanda as safe can be suspended in accordance with material conditions and or non-compliance with obligations. I'm willing to give way.
The Honourable Lady for giving way, and Right Honourable Lady for giving way. She will know that under this government and previous governments of all political colours, many people are deported from this country. People who are here illegally. When that happens, invariably, it is notwithstanding claims they make about their circumstances. Sometimes those are claims about their personal circumstances, sometimes they're claims about the place they're being deported to and from where they come. On the basis of her speech so far, she would deport no one.
I don't know if I am grateful to the Right Honourable Gentleman for that intervention, because that's clearly not what I'm saying. What I'm saying is, and the Home Affairs Select Committee is very clear, is about the rule of law, recognising the international obligations that this country has freely entered into, and doing things properly and legally. And that's what I'm questioning, that some of the proposals that are being put forward today by honourable members opposite are going to the heart of the common law that we have in this country, and our belief in the right to go before a judge, to particularly if one is detained, that you cannot be detained indefinitely. These are important matters before us today. I want to just carry on, because there's a couple of other things I want to get into the record. Just going back to what I was saying about Amendment 1 and New Clause 6, I think while the government has determined in this bill that it's possible to stipulate in law that Rwanda is safe, to the contrary of finding a fact by the Supreme Court, as we know, it doesn't seem to me very sensible for the government to propose that that status should be fixed forevermore, with Rwanda, by extension, the only country on earth in which nothing can ever happen or change. So as such, Amendment 1 and New Clause 6, I think, have merit, which I hope the Minister will consider. Amendments 35 and 37 allow the courts to consider the risk of refoulement in decisions on removals to Rwanda. And given that the Supreme Court ruled unanimously that the Rwanda policy was unlawfully precisely because there was substantial grounds to believe that refoulement could take place, I also think that Amendment 35 and 37 have merit. Now, I understand from media reports that the Minister, when he gets to his feet today, is going to make give some undertakings about increasing the number of lower-level judges, or I should say moving lower-level judges up to the upper tribunal to hear any appeals, and this apparently is to deal with some of the concerns that honourable members on his side of the House have. I just wanted to say to the Minister that the Home Affairs Select Committee is very concerned generally about the lengthy delays in court cases, and particularly in one of our recent reports on the investigation and prosecution of sexual offences, and particularly rape. We were very worried about how long it was taking for those cases to be heard. So this initiative that the government have come up with, or perhaps I'm prejudging what the Minister's going to say, but it's being reported in the press, I am very concerned that there's this amount of resource and finance that's going to have to be put into training up this 150 number of judges. It does strike me that the government seem to be using an enormous amount of political time, resource on this particular policy, and I'm looking forward to what the Minister has to say about this issue of increasing the number of judges when we seem to have so many other problems in other parts of the court system that the government haven't so far been able to deal with. And I also, at that point, Sir Roger, I think that concludes my remarks on the amendments that have been tabled today.
5 minutes. Sir Robert Buckland.
Thank you, Sir Roger. It's a pleasure to follow the Honourable Lady, the Chair of the Home Affairs Select Committee. I rise to speak to amendments 28, 29 and 30 tabled in my name relating, although they relate to Clause 9, they relate to the operation of Clause 2, hence their selection for debate today. And I think it's important that we focus in Clause 2 on what that actually means, what its effect is, and what the changed reality is with regard to the position in Rwanda, and indeed the position between the United Kingdom and Rwanda since the not just since the decision of the Supreme Court in November, but the facts upon which the Supreme Court based their decision, which of course relate to the spring, early summer of 2022. There is no doubt that matters have moved on, and moved on quite significantly. Not only do we have a treaty between the United Kingdom and Rwanda that was signed late last year, but we also now have, in the form of a policy document published by the government, and indeed further information, an indication as to the hard and fast changes that the Rwandan government in particular will be making in order to, in effect, answer the questions asked of it by the Supreme Court decision. Because, Sir Roger, the Supreme Court decision really wasn't about the law, it was about the evidence. And when we look at what the Lordships decided, the Supreme Court justices rather decided, it was very much narrowed down to that issue of whether or not refoulement was still likely, bearing in mind the position of Rwanda. Now, the court decided that it was. That's the sole reason why the policy was held to be unlawful. There were other grounds that were tendered in that case. One on retained EU law was a specific ruling of the court that, of course, it didn't apply. The law was very clear that that part of retained EU law had fallen with our departure from the EU. Other aspects of the claim, the appeal, were not ruled upon by the court. So it wasn't a decision based upon compatibility with the ECHR, for example. It wasn't a decision, importantly, that was based upon a challenge that was upheld to the legality of the removal of people to third countries. In my view, it's neither illegal nor immoral to move to seek third country assistance when it comes to this unprecedented challenge. Other European countries are indeed either doing it or wish to do it. And as my right honourable friend, the member for Newark, said in his remarks, he's right to say that other countries are looking to what happens here with regard to the precedent that we might set. In setting precedents, we have to tread carefully, Sir Roger. And that's why the amendments that I've tabled are very much focused towards the factual reality and the need to make sure that Rwanda does indeed carry out its policies. And looking carefully at the policy statement, there are particular tasks that will need to be completed. First of all, new operational training for decision makers in Rwanda. I think the latest figure that we have is that over 100 people have now been trained to implement the deal, and that there need to be clear standard operating procedures with regard to the reception and accommodation arrangements for asylum seekers, safeguarding of their welfare and access to healthcare. And of course there needs to be strengthened procedural oversight of the Migration and Economic Development Partnership that was agreed in 2022 and the asylum processes under it. And that means that bodies have to be set up. The new MEDP Coordination Unit, the MEDP Monitoring Committee of Experts, and the involvement of experts, certainly in the early days of the decision-making to be made by the new body at first instance, which will be set up by the government of Rwanda, and a new appeal body that will consist of panels of 3 judges with subject matter experts, including Rwandan judges and indeed judges from other Commonwealth jurisdictions. All these details are important because they go to answer the question that I think will be in the affirmative, that individuals in this scheme will not be at risk of refoulement and therefore there will not be a breach of the 1951 Convention. That reality has to match the deeming provision. And I know that my right honourable friend, the Minister, will be anxious to make sure that deeming provisions do not either perpetuate or encourage fictions, legal fictions. This is difficult law. But it's not unprecedented. Deeming provisions are, of course, used. They're very often used in tax legislation, and the leading authority is a fairly recent one, Fowler and Her Majesty's Revenue and Customs back in 2020, where it was made very clear by the Supreme Court, I think it was Lord Briggs, who said that deeming provisions creating statutory fictions should be followed as far as required for the purposes for which the deeming provision was created. But what will not be encouraged is the production of unjust, absurd or anomalous results. That's clearly something where the courts do not wish to tread and don't wish to encourage, and neither should we as a government or indeed as a parliament. And that's why making sure that we dovetail the coming into force of these deeming provisions with the reality on the ground in Rwanda means that we're not, in effect, creating a statutory fiction, we're creating a series of facts that is then reinforced by statute. And I think it's that degree of care, and it doesn't have to take ages to do. This can be done in weeks, bearing in mind the quick work that's been done already. This, I think, will go a long way to satisfy the natural concerns that many of us will have about the use of such provisions. We understand why it has to be done. We don't oppose the principle of its use, but we, and I certainly simply just caution that we take care to make sure that we get that coordination right. And now, many of us have been down the road before about ouster, and it can take many different forms. There have been examples, Sir Roger, where ouster proceedings and ouster clauses have clearly not worked. And indeed, it's not the sole province of this government. We saw previous Labour governments try to enact very bold and sweeping ouster clauses, only to find their efforts fell flat, either before the Act became law or indeed as a result of court intervention. I can think of the Asylum Bill of 2004, where Labour tried to be too extensive and expansive. And that's why experience has taught us that where we have very clearly defined reasons, and importantly, where there are limited exceptions, then ouster clauses will work. And we had a recent example of that in the removal of the carte jurisdiction, the Judicial Review Act that my honourable and learned friend, my right honourable and learned friend, finished the job on, which I started the job on in the consultation on the Judicial Review provisions that my noble friend Lord Folkes and others embarked upon at my direction. And that worked. It's been tested not just in the High Court but now in the Court of Appeal in the Oceana case, and it's held to be sound and watertight. Why? Because there was a very clear rationale behind it, and secondly there were limited exceptions. And herein lies the danger, I'm afraid, that is posed by the otherwise well-intentioned amendment by my honourable and right honourable friends. If you don't have those limited exceptions, you're setting this up to fail, Sir Roger. And that's what I think history has taught us. I'm absolutely a proponent and a strong believer that it is from this place that the core of our constitution comes. It is from Parliament that our constitutional authority is derived, and that to contradict the honourable gentleman member for Aberavon, who in many respects I think characterised and couched his remarks well, we're not a separation of powers constitution. We're a checks and balances constitution where each part of the body politic respects each other. And here I agree with him. I think restraint is an important principle. And I'll give, well, of course, to my right honourable and good friend.
My right honourable friend is making a very profound and important point about the nature of the separation of powers, and there is a lot of misunderstanding about this abroad. The separation of powers is not about equal bodies. It's not about each of those bodies performing the same role. It is entirely a matter, as he describes, of a balance between those bodies, and this House is the body that makes laws. Judge-made law is something he and I have debated and discussed and agreed on many times, and it is invidious because this House, as I said earlier, is supreme when it comes to making or changing law.
I entirely agree with my honourable friend, and he and I are both romantic Tories of an old school, which might surprise many members in that we do share that common fount of Toryism that is important to us both. And within that, we utterly respect the independence of the judiciary. It is a separate part of our constitution, and the idea that, as sadly in the Post Office case we've had to, that we trespass upon their domain is something we do extremely reluctantly, and I hope in a very rare and unique way in that very tragic and scandalous example. But that, as he says, does not mean that we are a carbon copy of the United States. In fact, the United States Constitution is itself based upon a misunderstanding of the British Constitution. And it is not right to say that separation of powers is the underlying principle. That fiction, I'm afraid, led us into error when we, to my mind, regrettably took the House of Lords Judicial Committee out of this place and pretended that somehow it was entirely separate from Parliament. The point about the House of Lords Judicial Committee, if I may digress for a nanosecond, Sir Roger, is that it was a body of Parliament making law. And that, I thought, was an elegant solution, an elegant response to our unwritten constitution. The same goes for the office I used to hold. What a mess the previous Labour government made of reform to the office of Lord Chancellor, which I thought was the embodiment of the checks and balances that we have in our constitution. It's a bit of cod philosophy that is overused and is not actually part of our system. But I will go on to qualify that in an important way before I give way to my honourable friend, the member for Gloucester.
But I just want to bring him back, in a sense, to the amendments today. And does he agree with me that between the absolute conviction of the honourable member for Aberavon and the opposition that this cannot ever work, and the absolute conviction of the right honourable member for Newark that he can only work with his amendments, there is actually a landing
any better or more economically than Secretary Blinken just did it now. We're going to follow on the way he's framed that with our panel here. Most of them don't really need a great introduction, and their bios are all in the program. So I'll just call up. Am I calling up everyone at one time? Should we all come up?